written this twice. The false claims of election tampering they made to the OAH were solemnly dismissed by the judge.
I'll explain what Krueger is referring to. Here's Krueger's October 20 letter to Mary Township officers other than Wayne Lee. Here's the part where Krueger says that expulsion from MAT would result in Mary Township losing its insurance, since MAT membership is required to obtain insurance from MATIT. The first red box says that Mary Township could become a member of MAT once Lee is no longer a town officer. Those I talked with about this thought this was a violation of state election law. Here's the order I received dismissing my complaint. 4 reasons were given. I thought the 4th was interesting. Since no one had filed to run yet, and since the filing date hadn't come yet, there was no campaign law violation, since there was no possibility of there being a campaign yet. Interesting, isn't it? You can engage in a campaign to oust a public official using coercive-like tactics such as a threat of loss of insurance, but it can't violate the law if the filing date hasn't arrived yet. You win some and you lose some. That's just the way it goes.
Only this week he implied that I was involved in violation of state and federal wiretapping laws. None of these things are true.
Sounds like Krueger is denying that he intercepted my emails. I sent 4 emails between December 21 and 29 to all the MAT board members concerning pretrial matters, since they were to serve as our judges at the January 5 hearing. I also CC'd Krueger. A 5th email was sent only to our district director. None of these 5 emails reached the MAT board members from me. Here is Krueger forwarding to the MAT board my December 21 email on December 22. Here is Krueger forwarding to the MAT board my December 22 email on December 22. As far as I know, the MAT board never received my December 23 email. Here Krueger is forwarding to the MAT board my email of December 29. This shows that Krueger got my emails and knew that the MAT board had not. When I sent the December 29 email, I got an immediate out-of-office reply from Krueger saying he would be back in the office on the 3rd. I did not think I could wait until 2 days before the hearing before the MAT board received that email. And so I called our district director and asked if he had gotten my email. He had not. Then, with him on the line, I sent him and only him a test email from another picklepublishing.com email address. He did not get it. But I got an immediate out-of-office reply from Krueger, even though I never sent him that email. Here's the Minnesota statute that prohibits intercepting emails. Here's where it defines electronic communications in a way that would include emails. Here's where it prohibits the interception of electronic communications. Here's where it says that the penalties can be a $20,000 fine and 5 years in prison. In other words, a felony. Here's where private persons who've had their emails intercepted are given the right to sue. And here's where it says a plaintiff who prevails can receive statutory damages of $10,000. With some exceptions, intercepting emails is a state and federal crime. Does what Krueger did fall under one of the exceptions? It's an important question that he should answer, but he's made no attempt thus far to answer it. If an employee's contract includes a clause that permits such snooping by an employer, then everything is fine. But in this instance, we have Krueger intercepting emails sent from someone he's accused to the judges. And those judges, the MAT board members, are Krueger's employer. Got it? Rather than the employer snooping on the employee, we've got employee Krueger snooping in his employer's email.
These towns have an opportunity to be heard today. This is not a court. MAT is not a government. This is not an adversarial process in which court motions are made. Witnesses are not called and evidence is not introduced. There is not going to be a debate among the towns and the board, nor are we taking comments from anyone but the supervisors of these 5 townships.
We've seen this line before. MAT claims to have had the January 5 hearing because of this statute. Did they really follow it, or did they violate it? Here are the rules MAT sent on December 20. The rules for the January 5 hearing. The reasons for termination were sent the next day on December 21st, like the rules here say would be done. But the reasons sent were too vague. If there was something incorrect in NCAT's resolution, then say what it was. but Matt refused. Krueger's reasons for termination sprung on us at the January 5 hearing went beyond what we received on December 21st. We have never yet received them in writing. Here's where the rules state that I, as a town clerk, will not be permitted to speak, even though Minnesota statute section 317A.411 required that I be permitted to speak. When Krueger, in the January 5 hearing, said there would be no motions, witnesses, and evidence, he was adding to the rules sent on December 20. He was way too late to do that, especially since I had already filed motions, objections, and discovery requests starting on December 21st. When Krueger said there is not going to be a debate among the towns and the board, what did that really mean? It comes across to me like our minds are already made up. Though we previously refused to discuss your concerns with you, we still won't. And to make sure you never try again, we're kicking you out. Since the NCAT resolution concerned problems with Krueger, Fenske, and Burdorf, none of these three men should have been involved in this process at all. They had serious conflicts of interest, and their refusal to recuse themselves made it impossible for this process to be fair and reasonable.
The towns were also given the opportunity to submit a written statement. These processes follow the statute that governs the removal of members in a nonprofit organization. We value our relationship with each of our townships, and we hope you do not let the bad actions of these 5 men and the consequences of them undermine our relationship.
What did the resolution call for? Positive, observable change by Krueger, Burdorf, and Fenske. If they refused, then it called for the MAT board to terminate them or call for the resignations. If the MAT board refused, then it called for the formation of a new organization. Since it didn't seem like they were taking our concerns seriously, I worded the resolution in a way that would get their attention. In that sense, the resolution was wildly successful. Here are the 23 specific changes we asked Krueger, Burdorf, and Fenske to make. See if you see any that are a serious problem and worth kicking out townships for MAT for. That first one, if it weren't for the Form 990s, the October 13th afternoon vote to kick out the 5 townships might never have occurred. The topic wasn't even on the distributed agenda. The Form 990s are required to be open for public inspection. Since the board members weren't getting the 990s despite Matt telling the IRS otherwise, I wondered what would happen if I stopped by to see them. And so in the morning of October 13, I stopped by to inspect the 990s, and in the afternoon, the MAT board voted to expel the 5 townships if the NCAT directors did not rescind their resolution and apologize. Number 6 there is moot now. That election was held at the end of January, but Miller resigned on July 21, effective August 11. The long delay, apparently, prevented the new director from being at the annual meeting as a director and from being involved in the election of board officers. One concern I had about the District 7 election in January had to do with this provision of MAT's bylaws, which permits the ousting of a board member by a 2/3 vote of the remaining board members. The board was split 7-6, and then after Miller resigned, it was split 7-5. What if Miller's replacement sided with the board majority? Then it would be 8-5. And that would give us a situation where 8-4, a 2/3 vote of the remaining board members, could oust the 13th. And then an 8-3 vote could oust the 12th. And an 8-2 vote could oust the 11th. And an 8-1 vote could oust the 10th. And an 8-0 vote could oust the 9th. If Krueger would push for expelling 5 townships that he admitted had done nothing wrong, contrary to Matt's Articles of Incorporation and bylaws, and contrary to state law, I wouldn't put it past him to try to pull off something like this as well. Number 8, what I would recommend is that Krueger and company use the concerns and questions of others as tools to improve and excel, rather than as ways to identify enemies who must be destroyed. MAT and MATIT are so intertwined. It seems to me that state law requires that the townships control MATIT, but MAT has sole control. Suppose Matt were to sue a town officer and that town officer were to turn in the claim to MATIT. How would the conflict of interest be resolved? If you don't like a decision by MATIT, you can appeal to MATIT's Board of Trustees. If you don't like the result, you can appeal to the MAT Board, and that's where it ends. The 5 MATIT trustees are all MAT board members. Number 18. Amor Township paid the nominal fee to MAT to file the paperwork for ARPA funds. MAT didn't get them filed in time, and Amor Township lost out on $50,000 in ARPA funds. I was told Krueger offered to settle for $25,000. Amor didn't want to go that low, and so Krueger then offered $10,000. What doesn't make sense about that one is that MAT's insurance deductible is $25,000. So why offer $25,000 instead of $50,000 if you'll only have to pay $25,000 anyway? Number 21. Fenske early on said that township insurance may cover county unit directors. So let's get it in writing, with the exceptions spelled out if there are some. And that brings us to the end of our program. MAT's Jeff Krueger Refuted. So what can be done to fix this mess? Here's some hypothetical possibilities. The last one seems the simplest, with the least negatives. Reason D for expelling a MAT board member from the board is other conduct, inconsistent with or detrimental to the mission, objectives, or reputation of the association. Wouldn't you say that the farce of a hearing on January 5, which claimed to be complying with Minnesota Statute 317A.411, but was in reality brazenly violating it, wouldn't you say that qualifies? What can be done? Tell the board majority to fix the problems or be replaced. Here are their names. If you think it's fine for MAT to pay for Krueger and Burdorf's personal private legal expenses, kick out our 5 townships and all the rest, then campaign for the ouster of the board minority. But somehow I think that the town officers of this state share many of my concerns. In order to turn things around, it will only take a few changes on the board. Thank you for listening and watching.